A preliminary victory for the PGA Tour in its legal battle against the LIV Golf was obtained, but there is yet much still to be determined. LIV, according to what Alex Miceli writes, golf attorneys made a number of mistakes, including missing the mark on their arguments for a temporary restraining order, but the conclusion to the antitrust lawsuit could be years away. Also subscribe to our channel before we continue. In the courtroom in San Jose, California, where Judge Beth Labson Freeman issued her ruling against the plaintiffs, Talor Gooch, Hudson Swafford, and Australian Matt Jones, the headlines from the courtroom read, "Judge does not grant a temporary restraining order." While these headlines are accurate, they're also misleading. Inaccurate due to the fact that the ruling is just one of the many that will take place in a case that still has a lot of potential to develop. This incident only had an impact on 3 of the events that make up the FedEx Cup Playoffs on the PGA Tour. The plaintiffs, realizing that the time was running out, made a last-minute amendment to their lawsuit to have the TRO petition apply only to the 2022 playoff tournaments rather than all PGA Tour events as the initial motion requested, which turned out to be the correct decision. At the outset of the hearing, Judge Freeman made a statement along the lines of, "I'll mention that I did receive the plaintiff's revised proposed order." And Mr. Walters, the attorney for the plaintiffs, "Thank you for that. I think that's a more realistic approach to the temporary restraining order. And frankly, consistent really with your briefing. And so that's greatly appreciated," the judge said in Mr. Because of this, none of the LIV golf players who are still active members of the PGA Tour will be able to compete on the tour until after the hearing for the preliminary injunction takes place, and Judge Freeman makes a decision about the motion to block the players' participation. Because this hearing does not include the same kind of urgent situation, the decision that results from it will probably not be made until much later in the year, or not at all until 2023. After rendering her decision on the TRO, the judge outlined her plan for the case, which included an evidentiary hearing connected to a motion for a preliminary injunction like occurring at the end of the September or the beginning of October, motions for summary judgment occurring in March of the 2023, and a trial that's occurring in August of 2023. The schedule was outlined after the judge rendered her decision on the TRO. In the meanwhile, there will be a number of motions and judgments that will guide this case towards its eventual trial. To continue with the golf metaphor, just because you make a birdie on the first hole doesn't imply you're gonna go on to win the event, even though the PGA Tour did win the first time around. So there are a great many holes that have not yet been played. The areas in which the TRO fell short of its goal. To be successful in the hearing for a temporary restraining order, Gooch, Swafford, and Jones required to prove all 4 of the conditions that were outlined in the legislation, which are as follows: that they will be irreparably injured without relief, that the threatened injury outweighs the harm a TRO would inflict on the tour, and that the TRO would serve the public interest. Number 1, that they have a substantial likelihood of success on the merits. Number 2, that they will be irreparably injured without relief. Number 3, that the threatened injury outweighs the harm a TRO would inflict on the tour. And number 4, that the TRO would serve the public interest. In the end, Judge Freeman was of the opinion that the plaintiffs were not able to meet their burden of the proof regarding the irreparable harm provision. She made it abundantly clear in her opening remarks that she was concerned with that plaintiff's argument. Before either party had the opportunity to argue their case, Judge Freeman stated, I am first and foremost looking at the issues of whether you have established harm and exigency that would be required for a temporary restraining order. I'm first and foremost looking at the issues of whether you have established harm and exigency that would be required for a temporary. I'm concerned that the plaintiffs have not presented a strong enough argument that they have suffered irreparable injury. It's not the case that the three people who brought the temporary restraining order would be prohibited from playing golf as a result of the injunction. They most certainly have the opportunity with LIV, and they have taken use of this possibility. Because of the plaintiffs had the burden to prove that they met all four criteria in order to be granted relief, the judge was unable to ever move on from the issue of injury, which in the end rendered the other arguments moot. It's likely that Rob Walters, the lead counsel member for the LIV, could have made a more persuasive argument on harm had he been made more versed about professional golf. But this didn't occur during the 2-hour hearing that was held. It's very obvious that Walters did not explain in an effective manner that the plaintiffs had limited opportunities to compete in major tournaments, and that the damage was both genuine and unanticipated. Because the PGA Championship, the British Open, and the Masters all allow previous winners to continue competing until at least the age of 60, becoming a former champion is the easiest way to compete in a major championship. After a player has won the US Open, the United States Golf Association grants them an exemption from competition for 10 years. Walters, the guaranteed number is $160,000, which is without a doubt a significant amount of money. Judge Freeman, well, these contracts provide for payments simply for appearing at the first tournament. All they require is for you to show up. Walters, yes, they do, but in order for them to make money and recuperate against the contract, they have to win money. So each one is unique in its own particular way. LIV has flatly refuted on many occasions that any recoupment is taking place, noting that money received from the signing deals is completely distinct from the money that's earned from playing in tournaments. On Tuesday in San Jose, it was obvious that LIV was outlawyered. But it's important to remember that this is just the beginning stages of a complicated issue. Share your thoughts on this in the comments and subscribe us before leaving.